Good evening, everybody. Good evening. Welcome. Welcome. I'm going to try a little bit different format tonight with where I'm putting my label, but welcome. Good to see you all. Good to see you. Hello. Welcome in. I have turned comments off so that I can read through this document that I've got for you tonight. So hopefully everyone has had a lovely day. It has been a very busy day in the legal world, so oh my goodness. But I thought one of the most appropriate cases we could review tonight would be the King versus Whitmer case. Hello, welcome, welcome. So I will be going through this case, everybody. It's not particularly long. It's about 20 pages, which is not particularly long comparatively. So we have a decision here from the Sixth Circuit, and this is specific to Michigan. Now, you may remember, everyone, a case with the same name out of Michigan that I have read during a live several months ago, and it has to do with the attorneys that filed for the election fraud in Michigan, claiming the election was false. Now, those attorneys were sanctioned monetarily, as well as told they needed to go and get further legal education because the district court here out of the Sixth Circuit had found that there had been some ethical violations. We had had frivolous filings, including the complaint. So, of course, all of the attorneys listed here, L. Lynn Wood, Gregory Rule, Brandon Johnson, Howard Kleinhendler, Sidney Powell, Julia Haler, and Scott Hagerstrom, along with Emily Newman and Stephanie Lynn Gentilla, have all appealed. So they were all sanctioned at the lower court level here for the Eastern District of Michigan. They were all sanctioned, and they appealed. So of course it went up to the U.S. Court of Appeals for the Sixth Circuit. So this would be the sister court to the D.C. Circuit that we've been talking about this week, everyone. So they did decide this case in holding that some of the sanctions, of course, need to be affirmed, but some of the sanctions were not proper. So the district court had made a few mistakes. So one of the best, thank you, John, oh my goodness. One of the absolute best things about this decision, everyone, is first, it's not too long. But second is that the Court of Appeals, we've got 3 judges sitting here, go through all of the evidence that has been used in these election fraud cases. So I'll be careful using certain words tonight, but I thought it was very valuable to take a look at how the judges view the evidence and whether or not, because of how things were filed, it was sanctionable. Now, there were over 800 exhibits that were filed. These exhibits were all brought in from all of the other cases that were filed at the same time. This lawsuit itself was filed, just to be clear, this is the case number right here, and it was filed November 25th of 2020. So this was a case, again, claiming that there were problems with the Michigan election. Of course, there were not problems, but let's take a look at the evidence, and that's what the court did. The ethics issue and the violation of certain rules claim that if you don't have a proper basis for filing a particular piece of information, you can be sanctioned as an attorney as part of bad faith and bad actions. So this will be the first and the start of a series going through those post-election cases, everyone, along with going through multiple pieces of filings out of the Trump cases that have involved perhaps some ethical violations. So let me dive on in, and I will turn on questions and comment after I finish this case here, and we can kind of talk a little bit further about what these different rules are. So I will kind of have the screen bumped out a little bit this way to just leave my label here at the top so that you know what we're talking about. This is the King versus Whitman appeal on the attorney sanctions. So welcome in everybody, and here we go. We have King versus Whitmer was the original case here. Also Benson regarding the city of Detroit was named as well. This is an appeal from the United States District Court for the Eastern District of Michigan at Detroit. We had Judge Parker, who was the presiding district judge. This was argued December 8th of 2022 and decided just this past June 23rd of 2023. We've got a 3-panel judge here that decided this case. Again, this is about whether or not the sanctioning of these attorneys for their filing of election complaints were appropriate or not. The judge did affirm in part and reverse in part. So let's take a look. Just want to make sure I'm in frame properly here. All right, there we go. So here's the opinion, everyone. All right, so Circuit Judge Cathledge, 3 voters and 3 Republican nominees to the Electoral College in Michigan brought this suit in a bid to overturn the results of the state's 2020 election. The complaint plausibly alleged that Republican challengers had been harassed and mistreated during the vote counting at the TCF Center in Detroit in violation of Michigan law. But the complaint also alleged that an international collaboration with origins in Venezuela, extending to China and Iran, and including state actors in Michigan itself, had succeeded in generating hundreds of thousands of fraudulent votes in Michigan, thereby swinging the state's electoral votes to Joseph Biden. Friendly reminder, there were 16 electoral votes, 270 totals, what you need to win. For this particular situation. Now, I believe they've got one less vote for this particular upcoming election. Many of those allegations, particularly the ones concerning the Dominion voting machines, were refuted by the plaintiff's own exhibits to their complaint. Other allegations arose from facially unreliable expert reports. Still others were simply baseless. The district court found the entirety of the plaintiff's complaint sanctionable and ordered all of the plaintiff's attorneys jointly and severally to pay the defendants and the city of Detroit's reasonable attorney fees. We find only part of the complaint sanctionable and thus reverse in part and affirm in part. Number 1, subsection A. On November 3rd of 2020, Michigan voters cast their ballots in the presidential election. As soon as the polls closed, teams of state election officials began canvassing the results, a public process in which officials and observers verify that the number of votes cast in each precinct matches the number of voters listed on the poll lists. This canvass concluded on November 17th. By the next day, every county in Michigan had reported its official results to the Secretary of State and the Board of State Canvassers. Michigan law allows any candidate with a good faith belief that he lost the election due to fraud or mistake to request a recount within 48 hours of the canvass's conclusion, citing Michigan law here. No candidate did so. As a result, on November 23rd, the bipartisan Board of State Canvassers unanimously certified results indicating that Biden had won the state of Michigan by 154,188 votes. That same day, Michigan's governor transmitted those results to the United States Archivist. Michigan's electors for the Democratic Party were thereafter considered elected under Michigan law. That ended the involvement of the board and governor in the election. B. This case began 2 days later on November 25th of 2020. Plaintiffs sued Governor Gretchen Whitmer, Secretary of State Jocelyn Benson, and the Board of State Canvassers, together the state defendants, asserting that they had fraudulently manipulated the vote through a wide range interstate and international collaboration to ensure that Biden would win. Plaintiffs alleged that unspecified foreign adversaries and hostile foreign governments had accessed Dominion voting machines, that Detroit election officials had participated in countless violations of state election law, including an illegal vote this and tens of thousands of these. I do need to be careful with my words at this point. I think I've hit my number limit. And that expert analysis shows that the results were fraudulent. As a result, plaintiffs argued that they were entitled to the elimination of mail ballots from counting in the 2020 election, meaning all of them, and an order directing the electors of the state of Michigan to vote for President Donald Trump. So again, just a reminder, because of these harms, they were arguing they were entitled to eliminating all of the mail ballots, that was the remedy they were seeking for the harm they felt had been done to them. Sidney Powell, Scott Hagerstrom, and Gregory Roll signed this complaint as the plaintiff's attorneys and 5 other lawyers. Emily Newman, Julia Haler, Brandon Johnson, Lyd Wood, and Howard Kleinhendler were listed as of counsel. On November 29th, plaintiffs filed an emergency motion for injunctive relief, which repeated the arguments and requests of the complaint. The Democratic National Committee, the City of Detroit, and Robert Davis, an individual voter with no particular stake in the matter, each filed motions to intervene as defendants, which the court granted. On December 7th, the court denied plaintiffs' motion for emergency relief, citing the district court's decision. Plaintiffs thereafter hired a 9th attorney, Stephanie Gentilla, to file an appeal with this court. Meanwhile, Michigan electors were set to vote on December 14th. Gentilla and Powell filed a petition for certiorari with the Supreme Court, urging immediate intervention because they said the case would become moot after the December 14th Electoral College vote. But the Supreme Court did not intervene, and on December 14, Michigan electors cast their votes for Joseph Biden. Subsection C. On December 15th, the city served plaintiffs and their attorneys with a safe harbor letter warning that the city would seek sanctions under Civil Rules 11 if plaintiffs did not voluntarily dismiss their complaint. Plaintiffs' counsel did not respond. On December 22nd, the state defendants emailed plaintiffs' counsel to seek their concurrence in upcoming motions to dismiss. Gentilla responded and declined. That same day, the city, the DNC, and the state defendants filed separate motions to dismiss, and intervener Davis filed a motion to sanction plaintiffs' counsel under 28 U.S.C. 1927 and the court's inherent authority. On January 5th of 2021, 3 weeks after sending the safe harbor letter without any response, the city moved for Rule 11 sanctions against the plaintiffs and their attorneys, asking the court to impose a fine to require plaintiffs' counsel to pay defendants' attorneys' fees and to refer them to their respective state bar associations for disciplinary proceedings. The state defendants joined the city's motion in full. On January 11th and 12th, plaintiffs filed motions to extend the time to respond to the pending motions to dismiss. The court extended that time until January 21st. On January 14th, however, plaintiffs filed a response announcing that they would voluntarily dismiss the complaint. So we'll just make a note that was January 14th. The state defendants thereafter filed a separate motion for sanctions under 28 U.S. Code 1927 against Powell, Gentilla, Roll, and Hagerstrom. In July of 2021, the district court held a lengthy hearing on the sanctions motions during which it questioned plaintiffs' attorneys about the suit. Linwood said that before he heard about the sanctions hearing, he had no idea his name had been on any filings in the suit. But he admitted he had offered to help Powell with the lawsuit, and Powell herself had said she specifically asked Wood for his permission before including his name on the filings. Emily Newman and Stephanie Gentilla, for their parts, each said their involvement in the case was minimal. The remaining attorneys did not contest their roles in the case. The court also discussed 15 of the plaintiffs' affidavits to determine whether the attorneys had conducted a pre-filing investigation as to the plausibility of their allegations. In response, counsel repeatedly argued that they could rely on affidavits without conducting any inquiry. The district court thereafter held the plaintiffs' counsel had violated Rule 11 by filing their suit for an improper purpose and by failing to conduct an adequate pre-filing inquiry into the legal and factual merits of their claims. The court further found that counsel had needlessly prolonged the proceedings in violations of 28 United States Code 1927, and that counsel had acted in bad faith, warranting sanctions under the court's inherent authority. The court thereafter ordered all 9 of the plaintiff's attorneys, jointly and severally, to pay the reasonable legal fees of the city and moving state defendants. The court also ordered those attorneys to attend 12 hours of nonpartisan legal education on election law and federal pleading standards, and directed the clerk to send disciplinary referrals to counsel's respective bar associations, which the clerk did the next day. The court denied Davis's motion for sanctions and declined to impose sanctions on the plaintiffs themselves. In a separate order, the court considered objections to the amount of the city's request. No attorney had objected to the moving state defendants' request of $21,964.75. Of the $182,192 the city requested, the court awarded $153,285.62. I guess I'm just used to moving it. But that should be unnecessary at this point. There we go. Oh my goodness. These 4 appeals followed. Lynn Wood, Emily Newman, and Stephanie Gentilla each appeal individually, arguing that their involvement in this case was too minimal to warrant sanctions. Roll, Johnson, Kleinhendler, Powell, Haler, and Hagerstrom appealed together, arguing primarily that none of their conduct was sanctionable. Number 2. We review the district court's imposition of sanctions for abuse of discretion and its factual findings for clear error, citing case law. Subsection A. We begin with Rule 11, which, in the district court's view, authorized almost all of the sanctions awarded here. That rule provides, in relevant part, that attorneys who present a pleading or motion to the court thereby certify that, to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, 1. The pleading, written motion, or other paper is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. 2. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modify, or reversing existing law, or for the establishing of new law. And, meaning all 3 pieces are required, the factual contentions have evidentiary support, or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. So we're citing Federal Rule of Civil Procedure, Rule 11B1 through 3. Number 1, as an initial matter, the district court held that the attorneys filed their suits for an improper purpose in violation of Rule 11B1. Specifically, the court asserted that what very clearly reflects bad faith is that plaintiffs' attorneys are trying to use the judicial process to frame a public's narrative, but another word for framing a public narrative is speech, and Rule 11 cannot proscribe conduct protected by the First Amendment. True, an attorney may not say whatever she likes inside a courtroom, citing case law here, but an attorney's political speech outside a courtroom, including political speech about a lawsuit, is irrelevant to a Rule 11 inquiry about the suit itself. To the contrary, parties and their attorneys are free to use litigation as a vehicle for effective political expression and association, citing case law here. That is true in election cases as in any other case. Speech outside the courtroom is what the district court apparently found objectionable here, but that speech did not show that counsel were motivated by improper purposes such as harassment or delay, which means it was irrelevant to the district court's inquiry, citing case law. And contesting election results is not itself an improper purpose for litigation, citing Bush v. Gore. Nor does the record show that counsel were otherwise motivated by improper purposes, citing First Bank. Thus, the district court did not identify any improper purpose supporting the imposition of sanctions under Rule 11b1. Number 2, the district court also sanctioned plaintiff's counsel under Rule 11b3, which mandates that attorneys engage in reasonable pre-filing inquiry to ensure that a pleading or motion is well-grounded in fact, citing case law. Rule 11 also imposes an implied duty of candor, which attorneys violate whenever they misrepresent the evidence supporting their claim, citing case law here. Thus, a court may sanction attorneys under Rule 11b3 for factual assertions they know or after reasonable investigation should have known are false or wholly unsupported. The first amended complaint contains 233 numbered paragraphs and over 800 pages of exhibits. Of the complaint's allegations, 60 are irrelevant for the purposes of Rule 11 because they quoted legal standards or described undisputed facts. The remaining paragraphs fall into 3 categories, to wit, allegations about Dominion's voting systems, allegations about statistical anomalies in the election results, and allegations about misconduct by workers in Detroit. The first part, so then the court will go through each of these respectively. So we'll start with the Dominion case. According to plaintiffs, the election fraud began with the election software and hardware from Dominion voting systems. And we're citing paragraph 4 of the original complaint, in case you're wondering what that citation is. Counsel devoted 61 paragraphs of the complaint to allegations about Dominion. Those paragraphs make out the following theory: that foreign oligarchs and dictators founded Dominion in order to help Hugo Chavez manipulate Venezuelan elections, that Dominion accordingly designed its software to include hidden stuffing features, and that foreign states, along with Michigan's governor and secretary of state, apparently then exploited those features during the election. Sub 1, origins. The complaint said the following about Dominion's origins. So we've set out the evidence that they're alleging, and now we're going to look through that evidence and see if it's valid or not. Smartmatic and Dominion were founded by foreign oligarchs and dictators to ensure computerized stuffing and vote manipulation to whatever level was needed to make certain Venezuelan dictator Chavez never lost another voting thing. A redacted declaration of Dominion Venezuela whistleblower. So we're citing a whistleblower report. Notably, Chavez won every voting situation thereafter. Here's the evidence. The plaintiff's sole evidentiary support for these allegations was the so-called Dominion whistleblower report, allegedly authored by an unnamed adult of sound mind who purported to be a former member of Chavez's National Guard. Yet the whistleblower report itself says nothing about Dominion's founding. Instead, it describes a conspiracy between a company known as Smartmatic and the Venezuelan government. Smartmatic is not Dominion, just as General Motors is not Ford. The report otherwise says that Dominion relies upon software that is the descendant of Smartmatic management system, but the complaint's allegation that Dominion was founded as part of a Venezuelan conspiracy to commit this was entirely baseless. The district court rightly concluded that this whole raft of allegations was sanctionable. Part 2 of the Dominion argument. The complaint also alleges that Dominion's systems were easy to hack and impossible to audit. By way of background, according to a journal article that plaintiffs attached to the complaint, modern election management systems come in 3 kinds. One is hand-marked paper ballot system, in which voters manually complete a blank ballot and then take it to a machine to be scanned and tabulated. Another is a ballot marking system, in which voters make their selections on a touch screen and receive a printed marked ballot to take to the scanner. And an all-in-one system, a single machine marks, scans, and tabulates the ballots without further action by the voter. The problem with the complaint's allegations regarding Michigan's voting system, simply enough, is that they are concerned that they concern different kinds of systems than the one Michigan actually used. As any Michigan voter could have told counsel, Michigan used a hand-marked ballot system, which one of the plaintiff's own exhibits, an article by Dr. Andrew Appeal, said is the only practical technology for contestable, strongly defensible voting systems. That plaintiffs attached Apple's article in support of their criticisms of the Michigan voting system illustrates how little counsel understood about the system they were criticizing. Similarly, the complaint alleged, by way of the Chavista whistleblower, that a core requirement of the Smartmatic software design ultimately adopted by Dominion for Michigan's elections was the software's ability to hide its manipulation of these from an audit. But hand-marked ballots obviously can be recounted and thus audited by hand. The complaint likewise alleged that Michigan officials disregarded all the concerns that caused Dominion software to be rejected by the Texas Board of Elections in 2020 because it was deemed vulnerable to undetected and non-auditable manipulation. We set to one side that the Texas decision came after the relevant decision by Michigan officials. For the Texas decision on its face concerned a ballot marking system, not a hand-marked system that Michigan used. And Michigan's contract with Dominion, likewise an exhibit, was limited to the hand-marked ballot system. Plaintiffs' own exhibits thus refuted rather than supported the complaint's allegations about the Dominion system used in Michigan, and an adequate pre-filing inquiry under Rule 11 includes reading every document one plans to file, citing case law. Observing that we are at a total loss to understand how attorneys can urge that they have made a reasonable inquiry into the facts and law of a case when their complaint is predicated on allegedly false statements in documents which they have not bothered to read. Plaintiff's inquiry as to these allegations was patently inadequate. Number 3 in the Dominion part of the complaint. Plaintiffs' counsel sought to bolster their theories about Dominion with 2 putative expert reports. Attorneys are rarely sanctioned for relying upon experts. Expert testimony, by definition, rests on specialized knowledge, according to the Federal Rules of Evidence, Rule 702, and consulting an expert is itself a way to investigate a claim's factual plausibility. But there was no Rule 702 exception to Rule 11. An attorney's reliance upon a putative expert opinion must itself meet the standard of reasonableness imposed by Rule 11. That means the expert's opinions must not be unreliable on its face, either because of the expert's lack of qualifications or the substance of the opinion itself, and the attorneys cannot misrepresent what the expert himself actually says. Here, as to the alleged international conspiracy, the complaint alleged that Dominion software was accessed by agents acting on behalf of China and Iran in order to monitor and manipulate. The sole basis for that allegation was a report on the complaint called the Former Electronic Intelligence Analysis with the 305th Military Intelligence, with experience gathering SAM missile system electronic intelligence. But the intelligence analyst turned out to be a Dallas IT consultant who dropped out of an entry-level intelligence course after 7 months training. And even a cursory review of his putative report shows that it concerned the integrity of Dominion's public website, not its voting machines. That distinction should not have been hard for counsel to keep straight, and the complaint further misrepresented that when the complaint alleged Dominion allowed foreign adversaries to access data and intentionally provided access to their infrastructure, emphasis added. That allegation was utterly baseless. The attorneys also presented an affidavit from Russell Ramsled to substantiate their suspicion that foreign powers had hacked into Dominion's machines. Ramsled said that his background included advanced converged telecom, highly advanced semiconductor materials, hospitality, commercial real estate development, and operations, as well as running Europe's highest grossing Tex-Mex restaurant. His specialized knowledge as to foreign election interference was thus questionable on its face. More to the point, Ramsled claimed that Dominion machines had been manipulated in 4 precincts and townships in 4 Michigan counties: Wayne, Oakland, Macomb, and Kent, which he said resulted in 289,866 of these. Ramsled's theory was that the Dominion machines used in those counties, which he said were Model DRM 16011, lacked the processing capacity to count as many ballots as were counted in the relevant precincts on the night. But Ramsled likewise assumed that those counties used a ballot marking system nowhere used in Michigan, which showed that he did not know which machines were used in Michigan, meaning that his assumptions about processing capacity were baseless. Moreover, a simple internet search would have shown that Macomb and Oakland counties did not use Dominion systems at all. A reasonable pre-filing investigation would have shown counsel that their allegations about Dominion were baseless. Those allegations were therefore sanctionable under Rule 11b3. The next piece about statistics. In another part of the complaint, covering about 19 paragraphs, counsel relied upon several putative expert reports to allege that the results in Michigan were statistically anomalous or impossible. The complaint alleged that evidence compiled by Matt Brainerd using the National Change Address database showed that 13,248 voters who had moved to another state had nonetheless illegally voted in Michigan. But Brainerd's opinion came in the form of 4 tweets, each 280 characters or less, which said nothing about his qualifications or the data he supposedly employed. That opinion was unreliable on its face. Counsel violated Rule 11 by relying on it. Counsel also relied on a report by Dr. William Briggs, who, according to the complaint, opined that approximately 30,000 Michigan mail-in ballots were lost and approximately 30,000 more were fraudulently recorded. But Briggs drew that conclusion by taking as true a second Brainerd document, the so-called Brainerd Survey. That survey purported to describe Brainerd's multi-state phone survey data of 248 Michigan voters. Suffice it to say, Briggs' statistical extrapolations from that survey, 30,000 lost absentee ballots and 30,000 fraudulent ones, were facially unreliable as well. The complaint likewise cited Dr. Stanley Young, who asserted that Biden's gains over Trump among new voters in 9 large metropolitan counties, Oakland, Washtenaw, Wayne, Kent, Kalamazoo, were unexpected. According to Young, Biden received 190,000 excess votes in those counties because Biden's margin of victory there was 190,000 votes, greater than Clinton's margin had been in 2016. Every one of those counties has a large suburban population, which suggests a simpler explanation than an international conspiracy for that shift in votes. And by Young's logic, Trump received an excess of 29,000 votes in the rest of Michigan. Still, counsel could have reasonably relied on Young's opinion that the shift was unexpected. What the complaint actually said, however, was that Dr. Young's analysis indicates that when the entire state of Michigan is concerned, there were likely over 190,000 excess or likely fraudulent votes, which once again is significantly larger than Biden's 154,188 margin in Michigan. An unexpected shift in suburban votes in Young's report thus became, in the complaint, 190,000 fraudulent votes that swung the election. That allegation misrepresented Young's report and was sanctionable. Number 2, plaintiff's reliance on 4 other experts was not sanctionable. First, the complaint accurately stated Dr. Louis Bouchard's conclusion that several spikes in Biden's vote count in Michigan on election night were statistically impossible. Dr. Bouchard's reasoning was that the election results showed a tight race in both Florida and Michigan, that Biden's vote total in Florida had no corresponding spike, and thus the spikes in Michigan were anomalous. The proposition that Michigan's reporting of vote totals should track Florida's is without support, but Bouchard's technical analysis was not facially unreasonable to a layperson. Second, Thomas Davis asserted that the share of Democrats who voted by absentee ballot exceeded the share of Republicans who did so by a similar percentage throughout the state, which in Davis's view suggested that a computer algorithm had manipulated the vote count. Outcomes Razor suggests that Democrats just voted absentee more than Republicans did, but Davis's opinion that the consistency of the difference across counties was suspicious was not unreasonable on its face. Third, Dr. Eric Quinnell and Dr. Young together opined that Michigan's election results were mathematically anomalous because they said the new voters in several Michigan townships mostly voted for Biden. Their report appears to assume that everyone who voted for Trump in 2016 voted for him again in 2020, that everyone who voted for Clinton in 2016 voted for Biden in 2020, and that Biden then took an outsized share of new votes. Although those assumptions might be implausible, we cannot say this opinion was facially unreasonable. Finally, Robert Wilgus asserted that the number of absentee ballots that voters requested and returned on the same day warranted further investigation. The Michigan Constitution enables voters to do both of those things on the same day, so Wilgus's assertion that doing so warrants investigation is dubious, but his conclusion was tepid enough not to be facially unreasonable. Sub C. The third part of the complaint comprised 79 paragraphs of allegations of misconduct at the TCF Center, which is where the absentee voter counting boards counted all of the Detroit's absentee ballots. Number 1. The complaint's most provocative allegation as to these boards was that they fraudulently added tens of thousands of new ballots and new voters in the early morning and evening of November 4th. Perhaps the most probative evidence in support of this allegation, according to the complaint, came from the affidavit of Dominion employee Melissa Carone. She wrote, "There was 2 vans that pulled into the garage of the counting room, one on a day shift and one on a night shift. These vans were apparently bringing food into the building because they only had enough food for not even 1/3 of the workers. I never saw any food coming out of these vans. Coincidentally, it was announced on the news that Michigan had discovered over 100,000 more ballots, not even 2 hours after the last van left." On the basis of this affidavit, the complaint alleged that Carone had witnessed an illegal vote dump, as well as several other violations. That allegation illustrates the complaint's pattern of embellishment to the point of misrepresentation. The only thing that Carone said she witnessed was the arrival of 2 vans, period. Powell and her co-appellants now concede that Carone made it clear she saw no ballots. That means it was sanctionable to allege that she did, citing case law here. Counsel also used 2 affidavits copied from a state court case, Constantino versus Detroit, to support the illegal dump theory. The attorneys used the first affidavit from challenger Robert Cushman to allege that several thousand ballots had been fraudulently counted at TCF. Sorry, everyone, I need a tea break for a moment. Cushman was apparently a layperson as to election law, and in Constantino, Christopher Thomas, who served as Michigan's director of elections for over 30 years, submitted a detailed affidavit explaining that none of Cushman's observations suggested any violation of Michigan election law. Plaintiffs' counsel were not required to treat Thomas's affidavit as sacrosanct, but it reasonably A reasonable pre-filing inquiry before renewing Cushman's allegations of fraud would have included a review of Thomas's explanation and a reasoned assessment as to whether those allegations remained plausible. The record here reveals no such inquiry on counsel's part. The second affidavit from Constantino came from the election challenger Andrew Sito, who wrote in relevant part, at approximately 4:30 a.m., tens of thousands of ballots were brought in and placed in 8 long tables. Unlike the other ballots, these boxes were brought in from the rear of the room. The same procedure was performed on the ballots that arrived at approximately 4:30 a.m., but I specifically noticed that every ballot I had observed was cast for Biden. While counting these new ballots, I heard counters say at least 5 or 6 times that all 5 or 6 ballots were for Biden. All ballots sampled and I heard and observed were for Biden. An attorney could legitimately use an affidavit like Sito's to begin rather than end a line of inquiry regarding potential counting irregularities. But counsel here cited Soto's affidavit as proof of the most egregious example of election workers' fraudulent and illegal behavior at the TCF Center. That too was a gross exaggeration. Sito did not say that the tens of thousands of ballots he saw were fraudulent, nor did he say that the election workers treated those ballots any differently from any others. To the contrary, he said that the counters followed the same procedures as before. And though Sito had said every ballot he observed was for Biden, his affidavit implied that he heard only 30 or so votes that were counted. Number 3, the complaint also cited an affidavit from Artisha Boomer, who said she believed that some of the counters at TCF were changing votes that had been cast for Trump and other Republican candidates. The complaint called this eyewitness testimony of this workers manually changing votes for Trump to votes for Biden. That too was an embellishment, considering that Boomer offered no basis for her belief. Considered both individually and collectively, the affidavits cited in the complaint did not afford counsel a credible basis to allege that tens of thousands of fraudulent votes were counted at TCF. Those allegations therefore lacked the requisite basis in evidence. Number 2, the complaint also alleged various lesser violations of Michigan election law. The problem with those allegations, simply stated, is that counsel apparently did not read the statute they said was violated. For instance, the complaint includes 11 paragraphs of allegations about problems with verification of signatures and birth dates on absentee ballots at the TCF Center. But Michigan law does not require birth date verification for absentee voters, nor do the counting boards verify any signatures for the absentee ballots. Instead, by the terms of the same statute, the city clerk's office would have already done that before the Sorry everyone, we're getting to the last few pages, so it's a little harder to turn the page here, so just one moment. Ballots reach the TCF Center. Absentee ballots delivered to absentee voter counting boards must be accompanied by a statement by the clerk that the signatures of the absent voters on the envelopes have been checked and found to agree with the signatures of the voters on the registration cards. The complaint did not allege otherwise. Its allegation about improper verification at the TCF Center were therefore baseless. Counsel similarly alleged that voters who had requested absentee ballots later illegally voted in person. But the same statute specifies that Michigan law does not prohibit an absent voter from voting in person within the voter's precinct at an election. Notwithstanding, the voter may have applied for an absent voter ballot, and the ballot may have been mailed or otherwise delivered to the voter. And where the complaint did specifically allege double voting, as in paragraph 93, it misrepresented the supporting affidavit, which said only that some people who voted in person had already applied for an absentee ballot. Of a piece was a complaint's allegation that election challengers had been improperly barred from observing the ballot duplication process, meaning the process by which ballots that cannot be read by a machine are hand copied onto ballots that can be scanned. For the same statute says that, quote, at least one election inspector from each major political party must witness the duplication. Under Michigan law, challenger and inspector mean two different things. Election challengers are party volunteers with no official training in election procedure, whereas election inspectors are officials appointed by the Board of Election Commissioners. The complaint unwittingly used those terms interchangeably, and nowhere does it suggest that anyone barred an election inspector from observing the ballot duplication process. The statute at issue here ran 3 pages. A reasonable pre-filing inquiry as to all these allegations would have included reading it. Number 3. The complaint's remaining allegations about election-related events at the TCF Center were not sanctionable. One witness said that she had seen an election worker manually correct ballots that the witness thought should have been discarded as overvotes. The complaint fairly repeated that allegation. The same was true as to the allegations by 2 challengers who thought that they had seen someone move spoiled ballots to a to-be-counted pile. And counsel reasonably relied on the affidavit of one woman who said she'd seen a voting record of her late son, purportedly reflecting that after his death he had voted in the 2020 election. The complaint's most credible allegations were that election workers at the TCF Center mistreated, intimidated, and discriminated against Republican election challengers. Indeed, some 36 detailed affidavits, so thank you, Kristen, supported the complaint's allegations to that effect. Those affidavits were notably consistent in their description of partisan hostility at the TCF Center. For intense election challenger Abby Helminen attested that when the police removed a presumably Republican election challenger from the center, the whole room erupted in claps and cheers. This included the poll workers. She also said that Democrats outnumbered Republicans by at least 2-1. Similarly, Anna Pinalla wrote that she witnessed a pattern of chaos, intimidation, secrecy, and hostility by the poll workers, and that she saw workers cheer, jeer, and clap when poll challengers were escorted out. And Emily Steffens wrote that she was afraid to challenge any ballots because she had watched 2 GOP people escorted out by the police, again to cheers from Democrat volunteers and poll workers at the table. The intimidation and harassment alleged in these affidavits was potentially criminal, citing Michigan law. Any officer or election board who shall prevent the presence of any such challenger as above provided shall refuse or fail to provide such challenger with conveniences for the performance of the duties expected of him shall upon conviction be punished by a fine not exceeding $1,000 or by imprisonment in the state prison not exceeding 2 years. And the rank partisanship among election workers described in those affidavits undermines public confidence in elections just as much as bogus allegations about voting machines do. The district court should not have dismissed these affiances allegations out of hand. Number 3. The district court next held that the entire complaint was independently sanctionable under Rule 11b2. That rule requires attorneys to certify that the claims, defenses, and other legal contentions in their filings are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law under Federal Rule of Civil Procedure 11b2. Thus, in short, frivolous legal contentions are sanctionable under Rule 11b2. 3 of the complaint's legal claims, an equal protection claim, a due process claim, and a claim under the Michigan Constitution, relied exclusively on frivolous allegations of widespread voter fraud. That means those claims were already sanctionable in full under Rule 11b3. Thus, we need not consider whether the legal contentions in support of the complaint's voter fraud claims were sanctionable under Rule 11b2 as well. The defendants argue that the plaintiff's remaining claims rested on frivolous legal contentions. The legal contention is frivolous if it is obviously without merit under existing law and unsupported by a good faith argument to change or extend the law. citing case law here. As an initial matter, counsel never should have asserted any claims against the Board of Canvassers in this case. The board is a state agency, and unless the state waives 11th Amendment immunity or Congress abrogates it, state agencies are immune from federal suit. Here, the state did not waive immunity, and Congress did not abrogate it, and the plaintiffs have never argued otherwise. Hence, the board was indisputably entitled to sovereign immunity. Moreover, the board had already certified the election results by the time the plaintiffs sued, and thus lacked power to redress any of the plaintiffs' alleged harms. Hence, the plaintiffs also lacked standing to sue the board. The legal contentions in support of these claims, therefore, were frivolous. That leaves 2 federal claims against Governor Whitmer and Secretary Benson and a handful of state claims. The first federal claim was one under 42 U.S. Code Section 1983 for alleged violation of the elections and electors clauses of the Constitution. The theory behind that claim, as set forth in the complaint, was that the governor and the Secretary of State unilaterally chose to deviate from the requirements of Michigan Election Code. That this claim was one of unilateral action means it depended on action specific to the governor and secretary themselves, yet the complaint alleged no such actions apart from the conclusory allegation in the complaint's introduction about multifaceted schemes and artifices implemented by defendants and their collaborators, and that allegation itself obviously could not support this claim. Citing the Ashcroft case, this claim was therefore both legally and factually frivolous. A second 1983 claim against the governor and secretary was one for selective enforcement of election law in violation of the 14th Amendment's Equal Protection Clause. That claim presents a close question. As explained above, counsel had evidentiary basis for pleading the Republican challengers were disproportionately excluded from and otherwise discriminated against in the TCF Center. To make out a selective enforcement claim, counsel would have needed to plead that state actors intended to accomplish some forbidden aim through a truly discriminatory application of a neutral law. Although counsel spent only a single paragraph of the complaint on this theory, that paragraph was a non-frivolous attempt to state those elements. Counsel also requested injunctive relief targeting the alleged harms. That is not to say the claim would have survived a motion to dismiss. For instance, the complaint did not explain what role, if any, the governor and secretary played in the law's discriminatory application. On balance, however, this claim was meritless rather than frivolous. And that is a very important distinction, everyone. I would really note how important this is. Hence, it was not sanctionable under Rule 11b-2. The complaint also asserted several state law claims against the governor and secretary. We have already explained that counsel's claim under the absentee voting statute were sanctionable because the complaint failed to describe any violations of that statute. Likewise, frivolous was the complaint's attempt to state a claim under Michigan law, which merely sets forth certain criminal penalties for mistreatment of election challengers, but the complaint's claim under a neighboring election challenger provision was not frivolous. That claim had a factual basis as described above. Although that provision also does not expressly create a private cause of action, its terms, a person shall not threaten or intimidate a challenger while performing some 13 different activities, leave room to argue in good faith that one should be implied under Michigan law. This claim was not frivolous. C. The defendants argue that even the complaint's non-frivolous claims were sanctionable because the complaint's requests for relief were frivolous, but parties can tailor those requests as the case proceeds, and the complaint here included a request for any relief as is just and proper. That means counsel could have filed this lawsuit without any of the requests for relief that defendants say were frivolous. Those requests alone, therefore, do not render the non-frivolous legal claims sanctionable. Nor did the district court identify any other ground to support the determination that the entirety of this complaint was frivolous. Plaintiffs, for their part, defend the inadequacy of the complaint by pointing to the by pointing to the time constraints inherent in election contests. but Rule 11 imposes a safe harbor period to protect attorneys from sanctions for hasty mistakes. A party may seek sanctions only after providing notice of the alleged violations, which the opposing party then has 21 days to cure. Citing the rule here of Civil Procedure 11C, the timely withdrawal of a contention will protect a party against a motion for sanctions. Here, the city sent plaintiffs a detailed letter specifying the allegedly sanctionable material. Plaintiffs could have avoided sanctions by abandoning frivolous claims and allegations and concentrating the attention of the court on what remained. They did not do so, and that is why we uphold much of their Rule 11 sanctions today. In sum, therefore, the complaint stated two claims that were non-frivolous: a selective enforcement claim under 42 U.S. Code Section 1983 and a state law claim under Michigan law. Neither claim was sanctionable under Rule 11. We agree with the district court, however, that plaintiffs' other claims were all sanctionable under that rule. The same analysis, for the most part, applies to the plaintiff's motion for a temporary restraining order, but that motion focused exclusively on election fraud and contained only a single sentence on plaintiffs' non-frivolous allegations about election challengers. With the exception of the sentence on counsel's discussion of their experts then, the motion relied entirely on allegations that were factually frivolous and was to the extent sanctionable under Rule 11. B. The defendant also argues that the district court agreed that counsel are liable for the entirety of defendant's reasonable attorney's fees after December 14th because the plaintiffs failed to dismiss their case after it concededly became moot. Under 28 U.S. Code Section 1927, courts may award sanctions against an attorney who multiplies the proceedings in any case unreasonably and vexatiously. The court may award sanctions under this section when an attorney knows or reasonably should know that a claim pursued is frivolous and yet continues to litigate it. Here, plaintiffs themselves asserted in a petition to the Supreme Court that this case would become moot on December 14th of 2020, the date Michigan's certified electors would cast their votes. Yet, on December 15th, when the defendant sought plaintiffs' consent to a voluntary dismissal, counsel declined on the grounds that the district court lacked jurisdiction to dismiss the case while it was on appeal. That excuse was make weight. Plaintiffs obviously could have voluntarily dismissed their appeal and complaint alike. Hence, they unreasonably multiplied the proceedings by declining to dismiss their suit. The sanctioned attorneys now argue that the case gained new life when an alternative slate of electors for Michigan was advanced in early January. That formulation is passive for a reason. What actually occurred in January is that the, quote, alternative slate of electors, end quote, purported to elect themselves for the purpose of casting Michigan's electoral votes, and counsel do not explain why any competent attorney would take the self-election seriously for purposes of persisting in this lawsuit. Moreover, plaintiffs' refusal to dismiss their suit had concrete consequences for defendants who were forced to research and brief motions to dismiss that they should have not needed to file. The district court was right to impose sanctions under Section 1927. Finally, as noted above, the district court also invoked its inherent authority as an alternative basis for sanctions, but we need not review the court's exercise of that authority here. Unlike Rule 11, inherent authority sanctions require a showing of bad faith in addition to frivolousness. The court's inherent authority, therefore, does not support sanctions for the matters we have found non-sanctionable, and as to the sanctionable ones, Rule 11 and Section 1927 sufficed. Some of the attorneys argue they were not responsible for the sanctionable filings in this case. Upon finding a violation of Rule 11, the court may sanction any attorney who violated the rule or is responsible for a violation. An attorney violates the rule directly by presenting an offending pleading to the court, such as by signing, filing, submitting, or later advocating it. Separately, under 28 U.S. Code Section 1927, the court may impose sanctions on attorneys whose conduct falls short of the obligations owed by a member of the bar to the court. Here, the attorneys who appealed individually, Emily Newman, Stephanie Gentilla, and Lynn Wood, respectively, each argue that they are not responsible for any frivolous filing under either standard. Although Emily Newman's name appeared on the complaint, she did not file or sign it. And at the sanctions hearing, Newman said she played only a minimal role in the litigation. Nobody at the hearing argued otherwise. In fact, Powell told the court that Newman had no role whatsoever in the drafting and content of the complaints. And the district court made no factual findings to suggest that Newman was involved in drafting the complaint, the motion for a preliminary injunction, or any other filing that defended plaintiff's frivolous claims. Yet the court found that Newman was responsible for the complaint because it listed her as of counsel. The district court thus found Newman responsible more as a matter of form than as a matter of real responsibility. We therefore reverse the imposition of sanctions as to Newman. Stephanie Gentilla did not appear in the case until December 8th of 2020, by which time the other attorneys had already filed the complaint and a motion for a preliminary injunction. Yet the district court found that Gentilla had advocated those filings and had argued later that they were not, and she had argued later that they were not sanctionable. But to seek relief on a claim is plainly different from arguing later that the claim was not frivolous. Gentilla did only the latter. She never advocated the frivolous claims themselves. The district court's reasoning on this point was mistaken. Gentilla did personally decline defendants' request for a voluntary dismissal, but Gentilla said she lacked the authority to agree to a voluntary dismissal, and nobody argues otherwise. To the contrary, Powell, to her credit, candidly stated at oral argument that she was responsible for the decision to continue the case on December 14th. We therefore reverse the imposition of sanctions as to Gentilla as well. And finally, Linwood says that someone placed his name on the complaint without his consent and that he knew nothing about this case until he saw something in the newspaper about being sanctioned. But 2 months before, Wood filed a brief in the Delaware Supreme Court in which he represented plaintiffs challenging the results of the 2020 presidential election in Michigan and Wisconsin. Wood also tweeted about this case in December of 2020, 6 months before the sanctions hearing, saying that the enemy is running scared. Moreover, Powell said she did not specifically ask Mr. Wood for his permission to put his name on the complaint, and that she did specifically ask. I apologize for that. Moreover, Powell said she did specifically ask Mr. Wood for his permission to put his name on the complaint, and Gregory Roll submitted an affidavit stating that Wood spearheaded this suit. Suffice it to say that the district court did not clearly err when it found Wood not credible as to his involvement here. Nor, contrary to Wood's argument, was the district court's requirement to undertake an individual analysis of his conduct before it could sanction him. Wood also argues that the state defendants never sought any sanctions against him. The state defendants concede that point on appeal. Thus, as to Wood, we reverse only the court's award of attorney's fees to the state defendants. Number 2, the remaining attorneys argued the district court's sanctions were excessive. The district court awarded the city and the state defendants their full reasonable attorney's fees, required each attorney to take 12 hours of continuing legal education, and sent a referral for disciplinary proceedings to each attorney's respective bar association. Courts must limit any award of attorney's fees to only those expenses directly caused by the sanctionable conduct. When a filing is entirely baseless, sanctionable conduct causes every expense reasonably incurred in responding to it. But when, as here, a filing is partially non-sanctionable, courts may award only fees incurred in responding to the sanctionable parts. Here, given the district court's findings that the entire complaint was sanctionable, the court did not distinguish between fees generated in response to sanctionable and non-sanctionable parts of the complaints. We're on the last page, everyone, so I need to make sure I'm here in frame. Sorry about that. But courts are loath to prolong satellite litigation about fees, and here the record allows us to sort out those fees ourselves. The district court awarded the state's defendants $21,964.75 for 57.8 hours of work by 2 attorneys. The state's attorneys' billing records show they spent about 6 hours responding to various ways to non-frivolous parts of the complaint, including review of the expert reports on which counsel reasonably relied. Given the hourly rates for those attorneys involved, the work that amounted to $2,325 in fees. We therefore reduce the fee award to the state defendants to $19,639.75. So this was the original award. This is the modified award. The district court awarded the city $153,285.62, about $30,000 less than it had requested. The city's billing records show that its attorneys spent approximately 26 hours responding to non-frivolous components of the plaintiff's complaint and preliminary injunction motion. This work amounted to $8,450 in fees, which we will deduct from the city's award. Wood argues that the city's fee award included too many hours related to the sanctions litigation. The time and effort and money a party must spend to get another party sanctioned realistically is part of the harm caused by that other party's wrongful conduct. Thus, under Rule 11, a court may award fees incurred while pursuing sanctions. The record here, however, shows that the district court awarded fees for a number of tasks that bore little connection to sanctionable conduct in this case. Those tasks included, for example, reviewing a Michigan State Senate report about the election and responding to filings by intervener Davis, whose involvement in the case was no fault of the plaintiff's counsel. The billing records show that together these tasks assume 37.5 hours, which amounted to an additional $12,025 in attorney's fees. The district court abused its discretion when it included those fees in the city's award. With both of these deductions, then, we reduce the city's award to $132,810.62. So again, this was the original award, and this is the modified award here. The sanctioned attorneys also argue that as an intervener, the city could not receive more attorney's fees than the original defendants did. That argument is meritless. The city was all but compelled to intervene in this case, given, among other things, the plaintiff's request that all the absentee ballots from the city's residents be eliminated from the vote count. The attorney's remaining objections concerned the court's non-monetary sanctions, namely the disciplinary referrals and the required legal education. As an initial matter, we reject the state defendant's argument that the attorney's appeal of those sanctions is moot. Non-monetary sanctions cause continuing harm to counsel's reputation as attorneys and must present a live controversy even after an attorney complies with them. But we reject the attorney's arguments on the merits. They assert that the district court violated the local rule governing disciplinary referrals, but that rule permits such referrals rather than proscribes them. Nor do the non-monetary sanctions violate the First Amendment. We reverse the district court's imposition of sanctions against Emily Newman and Stephanie Gentilla, respectively. We reverse the state's defendant's fee award as to Lynn Wood. We reduce the city's award to $132,810.62, and we reduce the state's defendant's fee award to $19,639.75. Otherwise, the district court's imposition of sanctions in its August 25th of 2021 order is affirmed. So there you have it, everyone. I thought that was an incredibly well thought out and explained bit on how sanctions work against attorneys, along with including that evidence regarding these post-election cases. So we'll go ahead and turn on comments so we can do any kind of a Q&A if anyone has any questions. Okay, there we are. Hello, everyone. Welcome, welcome. Welcome in. Wow, well done. Thank you. Yes, this was a great case to go through how sanctions work, because they did a really great job. I think the district court worked really hard to get it right, but she didn't. She kind of missed it on a couple of things. Incredibly informative. Yes. Oh, I'm glad. I think a lot of people forget about this case. But it's a pretty important case because it's going against and explaining the evidence. So everyone's like, oh, look at all this evidence we have, or we have all this evidence. Like, well, this actually, let's look at the evidence. And no, you don't have it. Oh my gosh. Right. Why did Lynn Wood's sanctions get reversed? So just a piece of his sanctions were reversed with regards to the state. So he didn't have full reversal. He only had partial. So we reduced the city's, oh, here we go. Respectively, we reversed the state defendant's fee award as to Lynn Wood. So the fee award for the state defendants is all. So it was just a partial reversal here. So, and what they're really arguing with Mr. Wood here was just that the state defendants never sought any sanctions against him. The state defendants concede that point on appeal. So the state defendants didn't actually ask for sanctions. So, I think it was one of those, I don't think they checked the box kinds of situations. And so therefore fees were against them were waived. Is Woods going to be disbarred? Well, one would hope so. One would absolutely really hope so at this point. There's a lot of evidence here. A lot of evidence. For sure. Groups of Thomas's wife, perhaps, has to pay part of that. Yes, that's correct. Yes, he has to pay part of that. Who wrote it? So this was written by circuit judge out of the Sixth Circuit. So Judge Kethledge. Hold on, let me grab my map real quick. I did want to show you the circuit. Okay, so I made sure I had a map this time. Let me zoom you in. So our circuits are set up at the federal level. They're broken up into multiple pieces. So the DC circuit right here is right there. That's the one we've been talking about lately. Texas is the 5th circuit there. Colorado's in the 10th circuit. California's in the 9th circuit. First circuit over here, way east. And then New York's in the 2nd circuit, Pennsylvania the 3rd. We've got several southern states in the 4th, and the 6th district is right here. So Michigan is in the 6th circuit. And as you can see, this is Michigan here, along with this part. That's very important. That's Michigan. This part over here is in a completely different circuit. So I think that's important to note. The 9th is the best circuit. Well, I think we have different ways of looking at it. So the 2nd circuit is the only circuit that has incorporated the 3rd Amendment. So there's that for that. The 8th circuit just made a case on voting rights that wasn't particularly understanding of voting rights. So that just happened. Wisconsin is the mitten. Well, Michigan. Oh my goodness gracious. Yikes. I mean, my circuits, that's the only reason I say that. Oh, fair enough. Do they investigate how the county conducted themselves before removal? No. And, I think if anyone has ever, and I don't know what people's experiences are, but if you've ever worked the polls for a party during an election, it's pretty normal. But you have to know, though, in 2020, there was a lot of heat going on. And I will be the first to say that there was some very bad behavior on both sides. Now, what the reasons were for and against that, I know there's plenty, and it's not my job to charge anybody. But it would be incorrect to say that there was not bad behavior going on all the way around. Now, was it warranted? Is there a possible defense for it? Perhaps. I don't have all the details, but overall, there was some bad behavior. Move the paper up so we can see the comment. Yes, actually, that was going to be part of my new system. I'm so glad you reminded me, Steffi. I was going to move it up. So I set everything so that I could, do that. Hold on, let me bump this one back up again, too. I'm so glad you reminded me. Thank you. The bus incident. Oh, I know. I have no excuse for anybody at all, but I will say that it was across the board pretty intense. So not very good. Not very good. Oh, you bet, Steffi. I'm glad you told me. I'm so glad you told me. So, what rabbit? Where the mitten? Oh no! Oh my goodness. Oh, a little higher. Okay, everybody. Here we go. How's that? Is that better? The appeals court was very thorough. Yes, they really were. Again, so, and the reason why I was sharing this was, again, because we're here in the Sixth Circuit. So this is the circuit here. Michigan, Ohio, Kentucky, and Tennessee. That's the circuit that we're coming out of here when it comes to these sanctions. Oops, too high now. Send out emails begging us for the... Oh, I know. It's going to be hard. This next year is going to be hard, everybody. You know, there's caucuses coming up, primaries coming up. There's all kinds of stuff, and it's going to be hard. It's going to be a tough one. And I think all of this has really kind of shown, you know, the kind of the ugliness of it, because you have people like election inspectors who are even being brought in on these kinds of bologna sandwiches. I mean, it's a lot to ask someone to volunteer to do that. So yeah, it's difficult. So one thing that I think is worth noting, by the way, and I will again be coming back, I thought this was a great case to kind of open this series, going through the different post-election lawsuits, which I will be going through again, because the evidence in this suit is the same evidence that they use over and over and over again, everybody. It's the same premise. They're saying three things. One, the Dominion machines were an issue. Number two, statistically, things should not have turned out the way that they turned out. And three, there was something wrong with the election workers. Those are the challenges across everybody. So we had over 85 lawsuits filed with these same premises because that's all they could challenge. So I would give a friendly reminder to say, in Pennsylvania, we had the challenge all the way up to the U.S. Supreme Court, so Texas v. Pennsylvania, where Texas said, Pennsylvania, you ran your election bad, and so your rules are bad. The Supreme Court said, you know what, Pennsylvania runs its own show. That's how the law is written. So if you take that into consideration, I crunched a couple of numbers, and I use this term very loosely because I'm not a math person. But let me just shoot some numbers at you here. First of all, we had in 2020, let me move this out of the way. So we had Biden received 306 electoral votes. Now you need 270 to win, right? So this whole situation that has been going on with all of these lawsuits, Law and Order, that's funny. With all of these lawsuits have been over 36 electoral votes, because that's how many more electoral votes that Biden got than Trump. All right, he got 36 more votes. Now you only need 270. So if you look at Pennsylvania at the time had 20 electoral votes. So the United States Supreme Court has held your elections were fine. So there was nothing wrong with Pennsylvania's election. And that's by SCOTUS. By conservative SCOTUS, your elections are run by you. You did fine. So that's 20 electoral votes to pull away. Next, we have Michigan. We've got our Court of Appeals right here. And they're saying none of your evidence was proper. None of it was proper. And so Michigan has 16 electoral votes that year. If you put that together, we have 36 votes. So if you pull Pennsylvania and Michigan out and say the courts have held they were legitimate, and then we'll add one more. Let's go to a phone call that happened in Georgia where Mr. Trump himself said, I need more votes. I don't have enough votes. Georgia has 16 electors. So between Pennsylvania, Michigan, and Georgia, there was no way under the Electoral College that Trump could have won. It's impossible. So even if somehow all of the other states that they're alleging were fraudulent, even if all of that was true, which it's not, he still would have lost just by crunching the numbers. So that's really as simple as you can break it down. This election turned on 3 states, Georgia, Pennsylvania, and Michigan. I know there's several swing states, but these are the 3 states that truly are the ones that could charge for theft, which is what's really going on in DC. But this is it. This is all that was needed. This is what won the election. And we have the Supreme Court saying it was fine. We have the Court of Appeals and multiple courts issuing sanctions saying you filed terrible stuff because it was all false. And then we have Georgia, where we have an actual phone call with Mr. Trump saying, I don't have enough votes. So just those 3 states, that's it. When it comes to any kind of fraudulent questions or stolen elections, that's it. It's 3 states and it's over. Theft of what? I would say, I've been thinking a lot about this idea of stolen election, right? And because of how this whole thing is broken down, I feel like each of the people in the states had their election stolen from them because they brought into question whether or not their votes actually counted. So that's where I see the theft. I see a theft in Georgia and in Pennsylvania and Michigan, and a theft by Mr. Trump and his team by filing all of these lawsuits. So they've been sanctioned. The Supreme Court's already kicked it out. Michigan's kicked it out. And then in Georgia, he's already admitted it. So for me, I've got 3 confirmed states where I see there was a theft of a proper election. That's at least how I see it. And proper election. That's at least how I see it. I know we all keep talking about, oh, there's no evidence or the cases were dismissed, this, that, and the other. And I have all of that, and I will go through all of those cases, everybody. But after reading through all of those cases, looking at all of the facts that have been presented and going through all of this, truly, these 3 states are the ones that had the most, in my opinion, the highest level of theft because they were the ones contested that were clearly legal situations that were contested incorrectly and in bad faith. Yeah, I got to watch out the E words. Yes, we're defrauded in Texas. And that could be. I've not read, I just don't have the same level of evidence that I have for these 3 states. So for me, these 3 states, I would sue. If I was these 3 states, I would sue for damage to reputation. For me, because of how the court cases have fallen out. I have absolute proof, no doubt in my mind. Everything went how it needed to go and had proper numbers for these 3 states. And without these 3 states, you don't win. You just can't win. It's impossible. I know, VC. It does hurt. I mean, I'm not in any of these 3 states, and don't get me wrong, there were 7 states total. We have Nevada, we have New Mexico, Arizona, Wisconsin. We've got a lot of states involved, but these are the ones that decided the election. These 3 states decided the election, and these 3 states have been fighting tooth and nail in their legal systems against all of these lawsuits claiming that their elections weren't run correctly, and they have all been upheld. They have all been affirmed that their elections had been proper, or at least in Georgia, we have an admission of guilt in Georgia. So I would look at this as a confession in Georgia rather than a court decision. But it's these 3 states, everybody. These are the 3 states that won it. Hurts as a whole. Absolutely. Oh, yeah, Amy, I am too. I mean, again, don't get me wrong. There were a lot of states hurt here, but these are the 3 that won the election. Yeah. Why did Texas think they could sue? Well, it was a group of states. It wasn't just Texas, but they're the ones bold enough to put their names on the complaint. And they said, we just don't think you are you're doing your election laws correctly. And the Supreme Court said, you're out of line. You have no grounds. You have no standing to even bring this lawsuit. Yes, Michigan. Absolutely, Michigan. Fantastic. That was it. And Georgia has been severely traumatized by what was done to them. But Pennsylvania fought hard. They wouldn't allow even the alternate electors in Pennsylvania were like, wait a minute, we need to make sure this is written out correctly. So even the people involved in it were like, you need to add certain words in here to make sure that we're okay. So Pennsylvania was super smart when it came to the law. watching out for that. And Michigan was like, wow, you guys mess with us and that's not appropriate. Your facts are bogus. And Georgia's like, yeah, you need more votes, but we're not going to give them to you. It's too bad. Yeah, absolutely. Absolutely. Well, right. State rights. I know, right? But again, it's just a numbers game when it comes to the Electoral College. So I think if anyone needs to be upset about the election and how it turned out, it's because of how the Electoral College works. So if you want to be mad about something, be mad about the Electoral College. Don't go after the states, because these 3 states did their job. They followed the rules. They sent their electors in as was required by law under the Constitution. But if you're mad about it, it's because of the Electoral College. Have their license in some... Yeah, they're in trouble. There's like a trail of damage that is absolutely following it. That is absolutely trailing behind Mr. Trump. Just absolute destruction of law licenses, reputations. But and which was one of the reasons why I wanted to start tonight too, was so that we can start talking about these ethics. We had closing statements today in New York, and there were some questions. Closing statements can be persuasive arguments, that's fine, but you still have to follow the rules. And if you don't, you can be requested to have sanctions against them. Get jail time or probation. I have no idea. But it's so important, again, because they're one of the trifecta, if you will, one of the 3 keys, the 3 keys to the election. So I would say they're probably going to go after them pretty hard, I would imagine. I was trying to find the mitten emoji. You can find it. You can do it's in there somewhere. Had to retire early. Oh my gosh. Yeah. Someone asked, what can be done about states that did wrongful acts? Like presuming... Well, I think they're already being sorted the way that each state wants to deal with it. That's the other thing too, is we've got fake electors in Arizona. We got fake electors in New Mexico. We had a certificate, I think, in Nevada. Is that right? And then Wisconsin, they sued them. I mean, they're like, y'all are getting sued hard. So Wisconsin took care of it in a Wisconsin way. And then we had Michigan, we had Pennsylvania, and then, of course, Georgia. So these were the states that actually filed the false certificates with the National Archives, okay? So in each of these states here, we've got RICO. We've got the RICO. Yikes. Pennsylvania, they're careful because of how the wording was. So even the fake electors involved in it knew the language wasn't right and that they could get dinged. So they were careful about their language. And I think that saved them from criminal charges. Again, Wisconsin has sued. Michigan, we don't know what those criminal sanctions are going to be. Arizona is still investigating. Now, if memory serves, I believe I get New Mexico and Nevada mixed up, and I apologize for that, especially to you, Legal Dad. I apologize sincerely. But one of these has already charged multiple people. We had an indictment that just came out recently. So those, we already had some of those go in. So let's just say it was New Mexico. Does anyone remember? Let's say it was New Mexico. So we've got New Mexico's already charged. So we've got charges going in New Mexico. Arizona is investigating. Georgia's already got charges going on. Wisconsin took care of it in their own way. Michigan's also got charges. So there's really not much left, honestly. The only place really that's left is we don't have a determination yet in Arizona. And Arizona, okay, was Arizona the one that charged, Mads? Nevada. Oh, it was Nevada. Okay. So I thought Arizona was still waiting. We hadn't seen any charges yet. Nevada. Okay. So, right, because there was a statute of limitations deadline that came up. So we really only have Arizona and then one of the end states. I don't know. New Mexico, Nevada. Very different states, but yet I can't seem to distinguish them. Election workers in Arizona with indictments. Thanks, Mads. All right, so we even have charges then in Arizona. So technically, there's only one place left then, I think, which is either New Mexico or Nevada. I don't know. Now I think it's New Mexico. Can we sue Trump for trying to steal our election, our votes? Well, I think it would be hard for a full lawsuit to go forward. I would, right now, one of the best ways to go about things is when you try to see the criminal charges, how a criminal case goes, and then you can follow it up with a civil case. For example, O.J. Simpson, that's a terrible example, but if you have a criminal case, watch and see how it goes, and then you can use that same evidence in a civil case. At this point, the criminal equivalent is the DC case. So the DC indictment is the voters saying, you stole this from us, and we're charging you basically with attempted robbery, if you will, because he wasn't successful, but he tried. And that was that conspiracy, that attempt to deprive. So we have attempted robbery in the DC case. So that is where we're going to find out criminally how it goes down. After we see results in that, then there could be some talk about a civil action, but I really don't know what that would look like at this point. New Mexico. Okay, so it must have been Nevada then. It must have been Nevada. Don't tell legal dad. Sorry. Oh my gosh. Need to start comparing school board election. Yes, VC, I think that's a valid question. I think that's a valid question. I think there are definitely some concerns. Yeah, I'm not sure. Again, we've got you have to, in order to have standing, you have to show that there's been some kind of an intentional target and a particular harm that could be replicated. So if it was to be some kind of a class action, equal rights, civil rights action, that would be the only road I could see anyone going down. Would it be successful? I have absolutely no idea. But criminally, once we watch how that falls out, how things go with that, then the next step after that would be to go down a civil road. Can't even imagine this in the movies. Oh, I know. It really is. It's going to take a lot. I'm angry at what he did to Michigan. I am too. I mean, like I said, everybody, I don't say this lightly, but, we have 3 states here that won the election and have been terribly harmed because of this false bad information. Now, some of the information I thought was very interesting that the judges said, look, it wasn't frivolous. It just wasn't good. It wasn't going to be helpful for you. It wasn't relevant. It wasn't something that's going to be helping your case. I think that's just fine. And that's what the lawsuits are for, is for bringing in this kind of stuff and throwing it at the judge and saying, well, is anything here good? And then the judges say, yes, keep going. Or they say, no, you don't have anything here. But here, not only do we have judges say, no, you don't have anything, but not only that, you knew you didn't have anything and you kept running with it. And that's why there's sanctions, because you knew it. And if you didn't know it off the top of your head, if you had looked on Google for like 2 minutes, you would have figured it out. And they didn't. So because they chose not to do that, that's where the sanctions came in for those kinds of cases. So again, if you've got questions, bring them up to court. That's what court's for. But then you have to respect the decision of the court when they come back with the answer. Won't let me pin the comment, but there are charges in Nevada. Okay, there are charges in Nevada. All right, so it's New Mexico. Okay, everybody, it's New Mexico, which I think New Mexico was the one that was kind of the weakest of all of them, where they hadn't fully flushed everything out in New Mexico, if I remember correctly, for the win. Really? Oh, really? Okay, so we do have a lawsuit going? That's very interesting. You have a recap video on you? I will. Yes, I'm getting kind of more, trying to upload quicker, everybody, to my tube of you. Oh, but I will. How long will it take the judge to take his verdict on today's? Oh, Steffi, I've got no doubt in my mind he's already started writing. I have no doubt. An opinion like this, especially given as thorough as his order on summary judgment was, so you have to keep in mind the bulk of his summary judgment, the bulk of the case had already been decided. So he's going to need to kind of navigate through the intent elements of the final pieces of this case. But the, lion's share or the huge part of the case, he has already written an opinion on. So he's going to be very careful. He's going to be citing the record, citing everything, because he knows this is all going to be appealed, and he's exhausted. He doesn't want to make any mistakes. He's being targeted, so he's going to be very careful. But I have no doubt that we'll have a decision in a couple weeks. Yep. That sounds right, Mads. Yep, you got it. End of the month. Yep. Exactly. Centralized location to look at the photos of unidentified January 6ers. That's a great question. I would think on the FBI website, that's where I have a list of all of the criminal charges too. Every single case number for every single person that was charged. You can actually pull up their record. You can pull up their charging documents and see what their sentence was too. So I would think that would be in the same place. I can't believe you had, I know, Suze. Oh, I know. So this map, we were talking about the different circuits in the United States. We were talking about a case that was out of the 6th Circuit here. And then I was just kind of breaking down the electoral votes in the 2020 election and how it had happened. And if you crunch the numbers, then we have Pennsylvania, Michigan, and Georgia. Those 3 states are the states that decided the election in 2020. So it had nothing to do with any kind of, falseness or whatever. It's just a sheer numbers game. We have admissions in Georgia that he had lost the election. We have the U.S. Supreme Court in Pennsylvania saying you're good to go. And then we have the 6th Circuit Court in Michigan saying, not only is your evidence bad, but you knew it was bad, and so we're going to sanction you legally. So those 3 states, that's kind of Arizona absolutely helped. Don't get me wrong, everyone. We have several other states that were harmed. There was harm done. I'm just numbers-wise, if you just crunch the numbers based off of Biden getting 306 electoral votes and Trump not. So if you just calculate the number of votes, there was a difference of 36, and that puts these 3 states on the line. These 3 states had to be won in order for Biden to win, and these 3 states have been determined to have been properly won. Speaker, blur the faces in the photos? I'm not sure. That's an interesting question. Very interesting question. Permitted to continue with his personal rants in court. Well, John, that's a good question, everybody. And I know a lot of people are frustrated. But Judge Engron, he put his foot down and he sanctioned these attorneys and he's done a lot. He's already sanctioned them like tens of thousands of dollars already. He's had his gag order appealed twice. But it's still held. It's still strong. He had to kind of figure out how to keep the circus contained in his courtroom with all the issues with his law clerk. That man's been through a lot, and here he is like 2 hours away from it being over. And this dude's like, I want to talk. And it's like, okay, well, we could have a huge fight about it, and I could potentially see an appealable issue somehow. Or I could just give him 5 minutes and we could be done with this in 2 hours. It's kind of, that's how I see it. I see it as like, everything else has gone completely bonkers. Why not just give him 5 minutes and then we'll be done. We'll clean the record up later and we'll move on. That's how I see it. Is it correct or not? That I don't know. But I can see why he did it. I can see why. Let him sink his own ship today. Sarah, a lot of people feel that way. A lot of people certainly do feel that way. Again, if you're not, there's a lot of weird stuff that goes on in court, though, that goes on behind closed doors that people just don't realize. Like there are a lot of kind of odd little accommodations that people do get here and there that you just don't normally hear about it. And it has to do with judicial discretion. And it's nothing along these lines. Don't get me wrong. This is huge. This is a huge discretionary moment, but those kinds of things do happen. Like, if someone's a defendant and they want to just talk from, counsel's table instead of getting up, sometimes they're like, fine, just do it. Let's just get it done. Have you gotten a transcript from the courtroom today? I want to hear the voices. Oh, Matt, you're so funny. So Navy Vet sent me a link. So I've got to go take a look. I've got to go. As soon as I get the transcripts, everybody, I will be all over that. I will post a story and let you know exactly when I will do that. But as soon as it is available, although the only thing is, everybody, and here's my scary thought, I only have 2 reams of paper left and there's a blizzard coming. So that's 1,000 sheets. I'm hoping that'll get me through the blizzard. That's where my life is right now. I'm basing my life off of how many sheets of paper I have. Oh my gosh. Oh my gosh, that would be so fun. Oh my gosh. It was her PowerPoint for closing. Oh, thank you, Navy Vet. Thank you. I've got to pull it up and take a look. I'm so thankful for that link. It's very interesting, very interesting. I know, the paper situation. At some point, I do have emergency paper, everybody, but it's pink. So just in case of emergencies, I want to be Trump. That's so funny. Oh my goodness. It's at 11%. Yeah, I mean, right. But again, and I get it. But these 3 are the states. This is it. This is the election right here. And again, if it's frustrating, it's because of how the Electoral College is set out. I mean, that's just kind of how it is. Pink is perfect. Well, we'll see. If we get desperate, I'll have to use one. Although on the plus side, I had a new toner come just today. So I should be good. I'm going through about 1 toner a month now, everybody. Oh my goodness. Did a video on Donnie Two Scoops, said the judge just gave him enough. I think that's an okay analysis of that. I really do. Printer paper to help her. Well, technically, I could walk if I needed to. I could. There's a place close enough if I had to get paper. I wouldn't be able to get toner, but I would be able to get paper if I had to. Oh my goodness. Oh my gosh. Can these cases be used in Trump's DC case? So great question. And any case that sets a precedent or any case that sets out law, you can call that case law, you can call it common law, depending on, if you're for legal dad or for what's real. I'm just kidding, legal dad. But if you can rely on that when you're arguing cases, so on any of the appeals is when you're going to use that. This isn't something you would use actually in a trial court. It would definitely be something that would be written about in appeals. And that's really what's happening with a lot of Trump's cases, are that they're being cited in all of these appeals. Amazon wish list. Oh, that's so sweet. Honestly, the little gifts that everybody sends me, I tell you, that is plenty for me. That's all I need, really. I don't have, people have asked me like a Patreon or like a Cash App or, whatever. And, I'm so thankful for that. But at this point, I mean, I'm just literally, I'm good to go when it comes to just the little gifts during the lives. I'm so thankful for the support, everybody, and that's just perfect for me. It's just what I need for toner, for paper. So I need to have a Discord. Oh, somebody had asked me about that too, but I'm so thankful. Yes. It really doesn't take much, toner does take a bit much, come to think of it. But it's a few $100s, and that's, all that I need. And I'm definitely very thankful for all of the support and help that pays for all my toner and all my paper. And that's just the right amount, Demerch. Yeah, we do. I know. Oh my gosh, thank you, everybody. Look at it's raining toner. Oh my goodness. Oh, you're so sweet, everybody. A nail fun. Oh my gosh, that's so funny. Well, you could probably all guess what I got for presents for this holiday season. Oh my gosh, everybody. Oh dear. Oh no, what have I started? Oh my goodness, that's so funny. With my printer paper. Yeah, that's really it, everybody. That's all I need. As long as I've got toner and paper, I am just absolutely thrilled to come and hang out with everybody and go through stuff. So Claw and Order. That's so funny. I had the sweetest little person in my world, and her present this year was just 3 little sets of nails, and she's like, "Here you go," and I almost couldn't stop crying. I was like, "Oh, that's so sweet." So that's it. Yeah, printer paper, toner, and then I got my own sources for my nails. Oh my gosh. Yes, you can thank those at the nail. Well, yes, I'm very thankful, and I'm very supportive people around me. So, oh my goodness, several people kind of. Well, my significant other kind of has to plan things. He's like, "How much time do I have?" I'm like, "You've got 30 minutes. Grab a sandwich and get out." He's just running out the door with a sandwich. We love it. Oh. Yes, tea. I'm stocked up. I'm plenty stocked up, and highlighters too. I've got plenty of stash. I was able to. I think actually that was one of my very first. After my first few sets of lives, I was able to go out and just invest in some highlighters. That was back in the old days before I was going through so much toner. So it was very good. Yeah, I know. He just grabbed a sandwich because he doesn't have time to heat it in the microwave. I'm like, "You don't have time to heat that up. Get out." How's Pearl tonight? Well, she's okay. She's okay. I didn't know if you could tell or not, but she's almost done with her medication, everybody. Almost done. I'll do what I can in Pennsylvania. Thank you kindly. Appreciate that. But yeah, she's gotten me a couple times. We've gotten a few little bits and bobs, but you know what? She's almost done, and her sneezes are getting better. So that's what's important. That's the most important thing. Yes. Oh, did you hear her sneeze? Oh dear. She is so sneezy. She just, oh my goodness. She is feisty, and I love that about her. She's a real scrapper. I mean, I'm telling you though, all of the advice that everybody gave me, I'm so thankful for. Wrapping her up in a little burrito, that's worked out really well. Mostly the soft food worked out okay for a while too. So I gotta it's a moving target. So it's been great. She wanted us to know she's there. Yeah, she's just kind of glaring at me right now. Because I have a water bottle now that I keep next to me. So she's a little bit more laid back, which is nice. But I do have a water bottle. It just sits next to my tea. Oh my goodness. How did Trump limit his chance to appeal by talking? I don't think he limited it. I'm not sure it would really limit his chances. I think, it depends on how it's viewed, because if he's not sworn in, it's not evidence. And so if it's just a persuasive argument that the judge told him to stop saying, it's really up to the judge. The judge gave him his few minutes and he's like, "Okay, we're done now." And then the judge brought him back in to line. So Judge Engeron could have sanctioned him if he wanted to. He could have asked him to leave the courtroom, but he didn't. So it was really kind of Judge Engeron's show. So touching her paws so you can clip her nails. Oh my goodness, I need to. I was looking at those little claw covers you can put on the nails, and I thought, that's a great idea. That would never work, but it's a great idea. It's genius. Whoever invented that. I don't think it hurt him or helped. Yeah, Kristen, you might be right. I'm not sure. I can see both sides of it. I can see how it just really went to show again how he doesn't really understand what's going on here. So there's that piece. It certainly didn't help his case any, but yeah, he did. He stormed out. Yeah, they come off quick. I don't know. Nail caps. Oh my gosh, I know. Oh, you have 4. Oh, Katrina, that's so fantastic. I was looking at her nails, and they are, very white. So they would be the perfect base for any kind of accoutrement, but that would be wrong. So unfortunately, no, it's not. I try to look at things. If she can't find it in the wild, I try not to add it to her. So that might be too much. It might be too much. Coarse nail file, and then yes, I have been able to file a couple. I was able to get a couple in before it got too dangerous. Make them match yours. Oh my goodness, wouldn't that be fun? That's the only thing, though. I mean, if it's not out in the nature, like for one thing, like cow's milk, like I don't give her cow's milk because there's no way cats are drinking cow's milk in the wild. You know what I'm saying? There's no way they're tackling a cow and taking milk. So I'm like, that doesn't sound right. So we can't do that. So I try to keep it as natural as possible as an indoor cat that's pampered. Oh, bite their nails. Really? Yeah. Oh, I would be. Yeah, I'm just not sure about that. Have to play with their paws. Well, I will have to work on that for sure. They can't digest lactose. Oh, well, that's good. I didn't realize that, Suze. I'm glad. I love cream and butter. It's bad for them. They don't have the Really? No, I didn't know that, everybody. For some reason, I always thought that cats and kittens were all about the milk. But I did not realize that. New information, everybody. New information. They're not meant to be wild. True. Just no milk. Well, good. See, my cow theory was correct then. We'll go with that. We'll go with the cow theory. Oh, my goodness, everybody. Oh, my goodness. So, most mammals don't. Well, yeah. I mean, good point. They can have goat's milk. Well, that's interesting. I suppose they could probably take down a goat. I don't know. Goats are mean, everybody. They're mean. Goats can be really mean. I had a goat on a farm, and it almost ate my brother. I'm just saying. As they get older. Okay, good to know. Oh, my goodness gracious. I mean, who hasn't had a goat on their farm that tried to eat their brother? Oh, my goodness. Okay, good to know. I know. Yeah, they just eat anything. The goats. We had I'll give you a little insight. Again, I won't want to give away too much, but I did live on a farm for for a bit of time. And we had several different animals that would visit us. We were if you got into trouble, you came to our farm. If you were an animal, you were like the detention. We were like the prison for animals. Or if you're having kids. So if you're pregnant or you were in trouble. Anyway, we had a visiting goat, and my brother and I went out to just feed it, and it was like, hey, I'm just going to eat you. Oh, my goodness. Faster than the goat, true. And they're surprisingly fast, though. I think they can, throw you off because you can't tell where they're looking exactly. Delinquent farm. Yeah, it was. It really was. Thank you for everything. I'm learning, feeling better about. Oh, I'm so glad. I'm glad. Yes. It's good. I think it's important to, we got to learn, but it's good to have a few laughs. Group tonight, interesting questions. Absolutely. What's up in Wisconsin there? So, Wisconsin sued their fake electors, which I thought was very fascinating. So they went civilly. They're the only state that went civilly for the fake electors. So that's why they're getting singled out. Oh my gosh. Yes. Well, we have goats that you can actually hire to have them come and do your lawn if you want. I personally don't have we have goats that you can actually hire to have them come and do your lawn if you want. I personally don't have the attack. Oh my gosh. Always be a rooster. Oh my gosh. Roosters. Yes. Well, of course. And for anyone who's ever had a chicken coop, I completely understand. That's not fun. And also if you only have delinquent chickens too, that's never good as well. No, seriously, yeah, you can rent a goat. I mean, it's a group of goats, but there's a goat wrangler. And he brings over the goats and releases the goats on the lawn and then does this whistly thing and then they come back. Oh my goodness. Oh my goodness. Oh my gosh. Thank you for the gifts, everybody. Absolutely. Great. Really, they're great. They're great at clearing brush. They do great work. I sometimes just go visit them. I mean, I watch from the car because of, past trauma, but oh my goodness. Well, that's really all I have for you tonight, everybody. What's the advantage of going civil versus criminal? Great question. Criminal has a much higher standard and a lot more evidence. Evidentiary rules. So, what's allowable, what's not allowable? The state has a higher burden, and the state has all the resources. I mean, more than most people do. So, I think criminal is always good because it helps to see where the holes are in the case. So, if you have a criminal versus a civil case, a lot of times, if you go criminal first, then you can use what was used in the criminal case in your civil case. So if you had a civil case first, a lot of that evidence isn't going to be able to be produced and shown in criminal trial because of our evidentiary rules. But if you have a criminal case first you can figure out what the holes are, you can figure out where your evidence is weak, and then you can even use some of the findings and some of the evidence out of that criminal case in the civil case to prove it. Yep, it's a fascinating way to do it. So, but yes, thank you everyone for joining me tonight. Now, I do plan to come back on again tomorrow. I've got some fun things to go over. Again, I've got plenty more things to go into. So as long as I've got internet and power, I will be back again tomorrow, 7 o'clock Central Time, everybody. So thank you again for coming and hanging out and for all of the wonderful gifts. So I will go and buy more paper. I will be able to have plenty of paper, so replenish my supply. So take care, everyone, and have a wonderful, amazing night. And I wish you all the very best. I will be back again tomorrow. So thanks again for coming, everyone. And as always, thank you to the moderators. You are all amazing, each and every one of you. So thank you so much, everyone. Take care.